The US Supreme Court has outlawed race-conscious admissions to American universities. Principal among them, certainly the best known among them, Harvard University, a party to the case following several cases in other courts earlier. We do need to pick the language here carefully. Race-conscious does not mean racist, as usually understood, though some allegations along those lines too were brought against these universities. It was argued against the universities that Asian Americans were being disadvantaged in admission. By Asian American here, we are talking about people more of East Asian origin, not really of South Asian origin. But through examination of that allegation and the examination of admissions over a number of years, no evidence was found of such discrimination. The far bigger issue here is the affirmative action program put in place by several universities that sought to encourage admissions, particularly for Black and Latino students, though of course not on those grounds alone. Several universities have had such policies in place, recognizing that disadvantaged groups will stay that way without a little extra help towards the top. Among the universities to have introduced positive discrimination, if you like, has been the University of North Carolina, another party to the case, which until the 1950s did not admit Black students at all. This move to reverse discrimination now itself stands reversed. Such a policy was held by a very conservative leaning Supreme Court to violate the Equal Protection Clause of the 14th Amendment of the US Constitution. This will now have far-reaching consequences for the role that many universities have been seeking to play to lift the relatively deprived through up to the best education that America can offer.